Can you explain to me why exactly your client was not here today? Why exactly didn't show up?
I don't know why he's not here today. He was to be here, and I tried to call him this morning, and I didn't get an answer. I don't know if he's in an accident or what, but it really doesn't matter because, as the judge said, there's no facts in dispute. My client's not the typical eyewitness who saw somebody get shot, so his appearance isn't required.
Okay, now what exactly, just to kind of summarize what you spoke to the judge about today, what exactly are you guys here for again? What is your purpose? What are you looking to get?
Well, the purpose of a probable cause hearing, it's a relatively low standard. Is there reason to believe that a crime has been committed? There's a reason to believe that a certain person committed the crime. And I believe all those reasons are here. That Judge Fochione knowingly deprived the people of Stark County of $5,000 that belonged to him, regardless of what Mr. Morgan alluded to. Whether Fochione had a good motive or a bad motive's not relevant. The Robin Hood defense doesn't work in the United States. Can't say I stole money to help a poor person. It's still a crime. So his motive's not relevant. And clearly he had to know that when he did that, contrary to law, he was depriving the people of Stark County of $5,000. I think it clearly meets all the elements of the criminal statutes, and I think probable cause should be found, but I don't know what this judge will do.
Now, how do you combat, I guess, the statements made by this gentleman over here about the intent is really what matters? Not, I know you're saying that he knowingly deprived, but how do you combat those statements made? Did you versus the act versus the intent?
Well, very few criminals will admit intent. So intent is proven not by an admission. First of all, a lot of criminal defendants never testify. But it's proven by the circumstances. And the Ohio Revised Code defines the term knowingly as meaning that you're probably aware that a certain result will come out of it. Well, Fochione had to be aware of the probable, if not certain, result that when he took money that didn't belong to him and donated it to an out-of-state charity, that would deprive Stark County of its own property. This notion of knowingly, the state doesn't have to, in fact, they're not allowed to put the defendant on the stand unless he or she agrees. They don't have to get somebody to admit they did it on purpose, they did it intentionally. It's inferred by the circumstances. And certainly for a sitting judge who's been an attorney for 25 years, he had to know when he unlawfully took money that didn't belong to him and sent it to Connecticut, that it would deprive the owner of those funds. And I believe that's a crime under Ohio law.
Okay, and then just one other question for you. I know there's been a lot of question kind of stirred up in the, with this whole entire case. How is your client really involved? I mean, he's out of Columbus. We know that he drove here to file all of this, but then today is the probable cause hearing and he's not here. So how exactly, what stirred him with all of this? Why is he getting involved?
Well, I really don't know for sure, and what I would know I couldn't share with you under attorney-client privilege. I think your radio station has reported that he grew up in Navarre. He went to Fairless High School. The Fochione matter gained national media attention, including in Columbus. This guy probably keeps up with local events. But other than that, I really don't know, and if I did know more, I wouldn't share it with you, but I really don't know more. I think he was just outraged that a judge would pull such a stunt and that it should not go unpunished.
In light of Mr. Conley's comments about your argument, your response?
Well, the key to any criminal case is not so much the act or the result of the act itself, but the key for any prosecutor is proving intent, the degree of intent. Actually, if you look at most laws, the degree of intent is the first element of any offense that a prosecutor has to prove. That's how much significance that our laws place on it. That's how important it is. And it's often the most difficult one to prove. A good example is, sexual assault cases, the non-stranger sexual assault cases. the parties generally agree to 98% of the facts. They agree that they both went somewhere, they agree that they both drank, they agree that they went back, they agreed that they were talking, and then they even agree that sex occurred, but what they don't agree on is what was going on up here in their minds. One person was saying yes and the other person was saying no. And the most difficult thing for a prosecutor to prove is what is going on in somebody's mind. So that's why when reviewing this affidavit, and again, I reviewed it in the light most favorable to Mr. Demas. I do not know Mr. Demas. I do not know Judge Fochione. I do not work here in Canton. I never have worked in Canton. When you look at it, it is void of any evidence or suggestion of intent. And a criminal case without evidence of intent fails before it even sees a trial.
This is the question that has to be asked. Did it make any difference at all to you that the defendant was a judge?
No, as I said, I don't know Judge Fochione. I've never practiced in front of Judge Fochione. I've practiced my entire legal career up in the city of Akron, with rare exceptions. I've been special prosecutor in Portage County and Starr County, whatnot. But no, it doesn't make a difference. What makes a difference is, can you prove a case? Can you prove a case beyond a reasonable doubt?
Now, I do want to ask you, talking about, Craig Conley made the comments. Well, Judge Fochione was an attorney for years, and now he's been a judge. How do you combat that being his representative, that he should know all this information, that he should know that what he's doing is technically could be, how he should know all the stuff that the prosecutor's bringing against him? Sure.
And I think, well, one key, I'm not the judge's representative. I wouldn't want to suggest. I'm here as the state. I guess I'm sort of the independent third party. And Mr. Conley, some of what Mr. Conley's inferring is mistake. Ignorance of the law is not an excuse. Okay, just because somebody doesn't know about a particular law, if they commit the violation, they're still, they're presumed to know about the law. And that's not really the issue here. That's not the issue for me, is whether or not the Judge Fochione in this case knew he was making a mistake, or knew that money belonged in the Stark County Treasury. Judges throughout Summit, Stark, Cuyahoga County encourage defendants sometimes to make charitable donations. I think they go about it different ways to make sure that an incident like this doesn't occur. The key here for me is whether his intent was, I'm going to deprive purposefully money from the Stark County Treasury, or was his purpose here, well, I want to try and help one tragedy with what occurred in another. So, and that's, for me, again, that's the big key here, is when you think of knowingly and being aware that your conduct is of a certain nature, that's the big key here. And I don't want to make it into an issue of semantics and the legal argument, but does somebody, are they really knowingly aware that their conduct is of a certain nature? I'm sure in this case, just going by the affidavits and everything that Mr. Conley provided me, I can't find any evidence that the judge acted knowingly. And again, that's the reason that I made the recommendations that I did.
What about the one case that Mr. Conley cited, where there was a public employee who neglected to collect a fee? I think he said a $5 fee. It added up not to a huge amount of money, and he points to that, I guess, to support his case against Judge Fochione. Any thoughts on that? I
can't speak on other cases. I'm looking at the facts involved in the case I'm presented with me today, and this is the one that I just can't find. That, again, we pursue cases that we feel like we have the evidence to prove each element. If we have to prove A, B, C, and D, C, D, and E are probably, the facts probably support most of the elements in this case. Did money go from one place where it was supposed to be to another place? That's the act. The big part is A, the most important element that the prosecutor has to prove. I can't find any evidence to suggest that he acted knowingly.
Because he seemed to say in that case that there wasn't any intent by that public employee. There wasn't any fraudulent receipt or cooking of the books or anything, and he still found her guilty of a crime, I believe. So,
yeah, like I said, I can't speak to that. I only know that with the offenses that have been filed here in this case, they both have a significant intent that needs to be proved, and that's knowingly. And lost in this, is the fact that the original affiant Mr. Demas is not present here in court today. And when we ask ourselves whether or not the whole process has it been done in bad faith, well, of course, it reeks of bad faith when the original affiant can't even make his, be up here. I mean, if we were to proceed forward with a case, he is our lead witness, he's our rock star, and if he can't even come here to talk to me about how this case would go forward, well, that's the interest that he puts in it.
Would you have asked him some questions? Or was
Of
that
course. Oh, of course.
Today at the probable cause
Yes.
hearing?
If he's asking me to pursue a case on behalf of the state, he has a lot of questions to answer for me, and that's how would I handle any investigation.
Yeah, 'cause
Had
I
you
think-
talked to him before today? Okay.
I think his attorney kind of inferred that it wasn't, I don't want to speak for the attorney, but my impression was that it wasn't, I don't know, central or relevant today, but you definitely disagreed that it was relevant.
Well, in any case, whether you have the lowest, like an assault case, which is a misdemeanor, or you have, something more serious, that's a felony, the victim in the case or the perceived, prosecuting witness, they're key. They're key to the case, and we can't, if we haven't had an opportunity to speak to them and discuss the matter with them and ask them the whys and the hows, and get a feel that they're being, judge their veracity and their truth, we can't proceed forward in good faith.
How did you come to be counsel in this case? Somebody from the Canton Law Department contact you and ask you?
Correct. It's not uncommon for prosecutors' offices to, as I said, I've sat in other jurisdictions, and we've had attorneys from other jurisdictions sit in our court everybody wants to make sure that there's no conflict. And as I said, in this case, I don't know any of the parties. I've never practiced down here, and certainly any recommendation I've made to the court here today has nothing to do with who the parties are.
Okay. What if the court finds there is probable cause? Does that present a problem with you prosecuting the case?
Well, that's the interesting thing about the probable cause affidavit, procedure, is ultimately, if the court were to find PC, it's still under the discretion of the prosecutor to pursue a case.
So chances are you wouldn't pursue it even if the court does find probable cause?
Well, I can't speak on that because he hasn't done it yet, but obviously I've already made my points about the lack of evidence I see in this case.
But that's how it would work. The recommendation would come from the judge. He would have, I guess, could you explain to me how that would work, the next step for the judge here after he reviews it?
Well, the judge, if I understand it correctly, the judge can find probable cause. And since this is potentially a felony, it could be presented to the grand jury at that point. Here, no. My only connection is I grew up in Stark County, but I left Stark County about 15 years ago. I grew up in Canal Fulton. But
So-
I don't think that had anything to do with me being picked.
So if you determine that you don't want to go forward with the case, it was your statement to Mr. Balin here was that it could go beyond that with someone presenting a case to a grand jury?
Well, it's still incumbent upon the prosecutor to do it. So
Would it be you or would it be somebody else?
I guess it would just depend.
Does the county prosecutor have any ability to go forward if you decide you don't want to prosecute the case?
I'll be honest, I don't really know for sure.
But it would be the prosecutor's call in this case, whether it would go to the grand jury
Sure.
or not. And then
Absolutely.
I'm not real familiar with a case like this. Could the judge also in his decision end it right there and it wouldn't even...
Well, one of two things are going to happen. The judge is either going to find probable cause, which means that the case could be presented to the grand jury, or the judge will not find probable cause. And if the judge does not find probable cause, then it's done.